Hi, my name is NATASHA. I'm from Group E of Tutorial Group 1. Today, my group will be presenting our answers on Task 1, Problem-Based Questions. I will be starting the presentation with Question 1, Scenario 1. For this question, the issue involves a fire caused by dangerous goods during a coastal voyage from Port Klang to Singapore. The shipper declared a container as metal parts, but it actually contained flammable solvent. During the voyage, the container caught fire and the fire spread, causing serious loss to cargo stored below deck. The cargo owners sued Oceanic Lines, claiming that the carrier failed to exercise due diligence and failed to make the ship seaworthy, while also failed to properly care for the cargo. For this scenario, the issue arises from a container that was declared as metal parts but in reality contained flammable solvent. During the voyage, the container caught fire and the fire spread and destroyed cargo stored below deck. As a result, the cargo owner sued Oceanic Lines, the carrier, for the loss. The legal issue here is whether the carrier is liable for the fire damage. This situation is governed by the Hague and Hague-Visby rules. In particular, Article 4, Rule 2b provides a fire exception, while Article 4, Rule 6 deals with a liability for dangerous goods. In applying the law to the facts, the goods were clearly misdeclared by the shipper, and the carrier had no knowledge of the flammable nature of the cargo. The fire was not caused by the carrier's fault, and Oceanic Lines has exercised due diligence through routine checks. Therefore, the fire exception applies, and responsibility for the loss rests with the shipper. In conclusion, Oceanic Lines is not liable for the loss, and liability lies with the shipper who misdeclared the dangerous goods.
Question 1 presents a separate scenario involving global grain exporters, Tropicana Mills, and Oceanic Lines. This scenario, wheat was shipped to Tropicana Mills under a negotiable bill of lading issued by Oceanic Lines. Upon arrival, the consignee tendered the original bill of lading. However, due to a porter's mistake at the terminal, the goods were wrongly delivered by the stevedores to a neighboring mill without production of the bill. As a result, Tropicana Mills refused to pay and sues Oceanic Lines for misdelivery and conversion. Oceanic Lines argues that the loss was caused by an innocent port worker's error and that the carrier relied on warehouse staff and contractual exclusion clauses. This question requires us to evaluate the carrier's liability with reference to relevant legal provisions and case law. Moving on to scenario 2, the main question is whether Oceanic Lines is liable for misdelivery and conversion when goods were delivered to the wrong party without the original bill of lading. Under the common law, a bill of lading is a document of title, and the carrier must deliver goods only to the holder of the original bill. Delivery without it, even by accident, count as wrongful delivery and conversion. This was confirmed in Hai Tong Beng versus Rambler Cycle in year 1959, where the court said carriers cannot avoid liability using exclusion clauses, as it would go against the purpose of the bill of lading. So in this case, Tropicana Mills had the original bill, but the goods were delivered to a neighboring mill due to a porter's mistake. Mistakes by staff do not remove the carrier's responsibility. The duty to deliver only against the bill is non-deligible. So, relying on port workers or internal processes does not excuse the carrier. Therefore, Oceanic Lines is liable for misdelivery and conversion, and Tropicana Mills can claim for the loss. Innocent mistakes and exclusion clauses cannot be used as a defense.
For this scenario, the issue is whether Oceanic Lines can avoid liability for fire damage caused by misdeclare dangerous goods and misdelivery of cargo without the original bill of lading. For the rule, under the Hague Bisbee rules, a carrier must exercise due diligence and properly care for the goods. However, there are differences, which is the carrier is not liable for fire unless it was caused by the carrier fault. If dangerous goods are misdeclared, the shipper is liable. For misdelivery, a carrier must only deliver goods when the original bill of lading is presented. Delivering without it usually makes the carrier strictly liable. For application, first, for the fire damage, the shipper declared dangerous goods as metal parts. Oceanic lines did not know the goods were dangerous. Routine checks were done and therefore the fire was not caused by the carrier. Second, for misdelivery, the cargo was released without the original bill of lading. Even though the mistake was made by a port worker, the carrier is still responsible. This is considered misdelivery under the law. For conclusion, oceanic lines can avoid liability for the fire damage. However, oceanic lines likely liable for the misdelivery.
Moving on to question 2, scenario 1. This involves a CIF contract between Orchard Exports as the seller and Baymil as the buyer. The seller shipped a consignment of rice, but the vessel sank during the voyage. 2 days later, the seller tendered a full set of clean on-board bills of lading, an invoice, and an insurance policy, all of which complied with the contract. However, Baymil refused to pay, arguing that the goods no longer existed. So, for this question, the issue involved a CIF Port Klang contract for the shipment of rice. The seller shipped the goods, but the vessel later sank during the voyage. Despite this, the seller tendered a full set of documents, including a clean on-board bill of lading, an invoice, and an insurance policy, but the buyer refused to pay. The legal issue here is whether the buyer must still pay when the goods have been lost. Under a CIF contract, this is governed by the principle that CIF contracts are documentary sales. Payment is made against confirming documents and risk passes to the buyer upon shipment of the goods. In applying this principle, the document tendered by the seller were clean and fully compliant with the contract. The goods were shipped before the vessel sank, meaning that the risk has already passes to the buyer. As such, the buyer remedies lies in claiming under the insurance policy rather than refusing to pay to the seller. In conclusion, the buyer is legally obliged to pay the seller because under a CIF contract, the obligation to pay arises upon tender of confirming documents, regardless of the physical delivery of the goods.
In this scenario, the issue is whether Global Foods breached the FOB contract by nominating the vessel late, and whether Orchard Export could be terminate the contract. For rule, in an FOB contract, the buyer must nominate a suitable vessel on time. Time clauses are usually treated as condition. If a condition is breached, the contract can be terminated. For application in this case, the buyer had to nominate a vessel by 1 June. Global Foods only nominated the vessel on 15 June. This delay affected the commercial purpose of the contract. Based on case law, this time obligation is a condition. For conclusion, therefore, Global Foods breached the FOB contract Orchard Export was legally entitled to terminate the contract.
I will now move to IREC 3, which concerns seller's termination under an FOB contract governed by the CISG. The issue is whether the Orchard Export can terminate the contract when Global Foods failed to nominate an effective vessel by June 1st under the Article 64, Sub 1, Paragraph A of the CISG. A seller may terminate the contract if the buyer commits a fundamental breach. According to Article 25, a breach is fundamental if it substantially deprives the other party of what it is entitled to expect. In FOB contracts, time is essential. So in this case, Global Foods only nominated a vessel on 15th of June after the agreed deadline. This delay deprived Orchard Exports of timely shipment and therefore constitutes a fundamental breach. So, as a result, Orchard Exports was entitled to terminate the contract under Article 64, Sub 1, Paragraph A without additional time. In conclusion, the termination by Orchard Export is valid and the seller is entitled to the relevant remedies. That's all from us. Thank you.